Welcome, everybody. If you are on this program, you've probably spent a lot of time reading cases since September. You may have the federal rules of civil procedure memorized, but it's hard to know what it's actually like to be a litigation attorney until you hear from people who are doing it. The thing about litigation is that the term is thrown around often as kind of one single category, but that is often a misconception. There are so many different types of litigation, and the day-to-day experience can look very different depending on the category of litigation that you're in. Examples include commercial litigation, appellate litigation, intellectual property or IP litigation, international arbitration. These are all categories that we're going to cover today, as well as others such as antitrust litigation, labor and employment, white collar, criminal, and the list goes on. If research, writing, crafting arguments, and other litigation-based activities excite you, and you want to get a sense of which specific types of litigation are for you, then you're in the right place. And if you're not sure what you want to do, but just want to hear more about what litigation attorneys do, you're also in the right place. So welcome to our Introduction to Litigation Practice Areas, another fantastic program in our Summer Associate Hub 2025 virtual series featuring some great firms tonight: Goodwin, Allen Matkins, Troutman, Pepper, Locke, and Fish and Richardson. My name is Albert from Summer Associate Hub. I'm proud to have all of you here. Before we jump in, a quick intro. What is Summer Associate Hub? Summer Associate Hub is a free content and resource hub for law students embarking on the 1L and 2L recruiting process. I'm a former law student and big law associate. We know from our own experience how hard it is as a 1L to understand what it's really like to work as a lawyer and engage with firms. Our platform, summerassociatehub.com, has blog posts, podcast episodes, short video tutorials, and exercises, interviews with attorneys, and other content to help you learn about practice areas and prepare for the process. We also host live virtual programs. That should be no surprise because you are watching one right now. Where students can easily learn directly from and network with law firm attorneys and recruiting team members. We have some really nice programs scheduled for this semester. We already had one yesterday. If you missed it, you can catch the recording. We're having one right now. And coming up, we have Introduction to Specialty Practice Areas. We have our Recruiting Director Q&A, our Junior Associate Q&A. We're also hosting a special program in collaboration with the Legal Mentor Network about the 2L job search, and that's next week on March 11th. So stay tuned in our newsletter for updates on all of that. We're also hosting our annual in-person job fair happening this May, and details will be sent to our newsletter following starting tomorrow. So make sure to stay tuned for that. If you're not already signed up, you can sign up at summerassociatehub.com/newsletter. If you signed up for this event, you've automatically added to the newsletter, so don't worry. All right, so jumping into to this event, we'll have our panel discussion for about 40 to 45 minutes. I know we started a bit late, so we'll try to keep that tight. At the end of the panel discussion, the firms have all graciously offered to raffle off some pretty fun swag. So we'll post a link in the chat for you to join the raffle, and we'll do that at the end. You have to be present to win, and we're gonna be calling your name live on the air if you win. So keep that in mind. At the end of the panel, at around 8:10, 8:15 Eastern time, each firm will host a separate breakout room where you can pop in, ask questions, and meet some of the firm's team members. The breakout rooms are all going to be available through this Zoom event. So stay tuned for easy instructions on how to do that later on. We're taking questions. We'll hopefully have time for maybe a question or two. If you have any questions throughout the program, just pop it in the Q&A, and I'll be monitoring that throughout the panel. And also just keep an eye on the chat. We're going to post links of how you can sign up with the different firms, links to how you can sign up for our raffle, and any other information that's helpful. All right, so enough for me. Let's start with some introductions. So we'll go one by one. I'll start kind of in order of my Zoom screen. Introduce yourself and your practice, and briefly why you chose to work in your practice area. So Andrew, I'm going to start with you.
Well, thank you, Albert, and hi everybody. Very nice to meet you. My name's Andrew Kim. I'm a partner in Goodwin's DC office as part of our appellate and Supreme Court litigation practice. A bonus practice is I also am the head of our gaming, gambling, and sweepstakes practice, so you'll hear a bit about that this evening. But I'm very excited to be with you all.
Fantastic. And why did you choose to go into that practice?
Oh, well, the appellate litigation practice. I interned for a judge my 1L summer and absolutely loved the experience and just the nitty gritty of thinking through an appeal and the everything and the consequences that an opinion might have, and shaping the development of the law was an exciting prospect for me at that stage, because when you're working in an appeal, you're not only just addressing error correction, but you're also, in a case of first impression, addressing issues that might have an impact beyond the case at bar. So that was exciting to me. And as an appellate lawyer, we are subject matter generalists, but procedural specialists. So it's exciting to be in a world where you get to do a little bit of everything. I will say the reasons for going into gaming and gambling law are far less exciting. As a second-year associate, I wanted to jokingly say that I was a fantasy sports associate. And here I am many years later doing actual gaming and gambling law still to this day. So that's me in a nutshell.
Fantastic. Thanks so much, Andrew. So Shauna, on to you. Tell us about yourself and your practice and briefly why you chose to go into your practice area.
Yes, absolutely. And I just also wanted to congratulate everyone who's here, because this is such a great resource that didn't exist when we were going through law school. And so I think everybody, attending today is far ahead of where the rest of us were. And I should also say that Andrew and I used to work together a long time ago. And so it's been fun to reconnect with him. So I am a commercial business litigator. So like Andrew, I'm a generalist, which means that I do a little bit of everything. And I love that about my practice, because I can learn everything there is to know about electronic locks for lockers in an antitrust case one week, and then the next week I'm on to doing something in a real estate matter. So I love having that kind of variety. It keeps my job interesting.
Awesome. Love it. Thanks so much. So Victoria, tell us about yourself, your practice, and why you chose to go into your practice area.
Thanks so much. Great to meet you, everyone. I'm Victoria Alvarez. I'm a partner at Troutman in our Chicago office. And my practice is a lot like Shauna's. I litigate disputes about a contract, and that contract can be about anything. It could be about the sale of a real estate building. It could be about a license agreement to distribute baseball cards. It can be about a joint venture agreement between two pharmaceutical companies. The difference is, instead of U.S. litigation, instead of U.S. court, I'm in private commercial arbitration, because the parties, usually one based in the U.S. and one based in a different country, don't want to litigate in each other's courts. So what they do is they pick a neutral private forum, and that's international arbitration. And there's different kinds. There's investor state, which is involving states, as the name suggests. There's specialties in construction or energy. But what I do is about contracts.
Why did you choose to go into that area?
I started out doing domestic U.S. litigation, and then when Legacy Troutman and Legacy Pepper merged, found myself doing more of the international work, and I love it. It is so interesting to work with lawyers from different countries. It is so interesting to learn about laws of different countries, and it's so interesting to learn about the nuances of each other's practices. Like British barristers, when they cross-examine, they put the question to the witness. So they'll say, on May 4th, you robbed the bank, didn't you? But in the US, we call that the one question too many. You never give the witness the opportunity to say, no, I didn't rob the bank. So it's differences like that I just find so culturally interesting.
Fantastic. Thanks, Victoria. And Jackie, last but not least, I'll go to you.
Yes, hello everyone. It's very nice to meet you. My name is Jackie Moran. I am a fifth-year associate in the Houston office of Fish and Richardson. I am a patent litigator, and what that means is that we represent entities that have patents that want to sue other entities that they think are accusing of infringing those patents. Alternatively, we also represent entities that have been accused of infringing a patent. The reason why I pursued patent litigation is because I wasn't really sure how else to use my neuroscience background. I became very disenchanted with the funding climate during my graduate school research, that I wasn't sure that academia was going to be a good fit for me. So I, at the time, wanted to explore other opportunities that I could use my neuroscience degree in without being at the bench and subjected to the funding climate in the US.
Great. Thank you so much. And Jackie mentioning her neuroscience background is the understatement of the year. It's I think Jackie's referring to her PhD. So we'll talk about that in a second. But thanks for raising that. A little bit later, we're going to ask about science degrees and how that could relate to IP litigation practice. So let's do a deep dive into each of your practices and hear a little bit more about what your day-to-day looks like. So Shauna, I'm going to go back to you. What are the typical matters that you'd work on and your day-to-day as a commercial litigation attorney?
Yeah, so again, it can be anything. Our firm, Matkins, is probably the best, actually it is the best real estate firm. By the way, all of my recruiting people were just silently saying, it's not probably, it is the best, and it is. Real estate firm on the West Coast, and we just actually opened a New York office. So we have a lot of real estate work in-house, and that can be anything that touches land, whether that's easement disputes, whether that's landlord tenant, whether that's a breach of lease, all of that we do. But then we also do the other side, which is everything. So I also do white collar. I do government investigations for the SEC against the SEC. And I also do a few appeals from some of my cases. So it can really be anything. Like one day, there was a year of my life where I spent defending Mariah Carey in a dispute with a former employee. And, you know, right now I'm in a dispute related to concrete franchisor and franchisee laws. So it really does just run the complete gamut. A lot of what I do at this point in my career is review the writing of the junior associates. Our junior associates get to do first drafts of everything, and they get to do sometimes depositions, and sometimes they also get to take witnesses at trial. So a lot of what I do is supervising that work and making sure that their skills are developing, and to make sure that the argument and the writing is still at the quality that I am known for and our firm is known for. So it's everywhere, and I love that. I love the diversity. I love working with younger lawyers to make sure that they build careers that they can really stand behind.
That's great. Thanks, Shauna. So Andrew, on to you. What are the typical matters you work on, or what does your day-to-day look like when you show up to work as an appellate litigation attorney?
I fear that we might have a common thread of there is no common day-to-day just because every day can be an adventure. So on the whole, I'll probably have about 10 to 12 cases sort of running at in different stages, in different courts. You know, I have 3 matters that are before the U.S. Supreme Court right now, mostly at the cert stage where the court is deciding whether to take up the case or not. I've got a couple of appeals, including a very complicated bankruptcy appeal that I will need to figure out at some point. And I've got we also work on district court litigation. Just because you're an appellate lawyer does not mean that you don't do trial litigations. Oftentimes we get embedded with trial court teams, so that if you're working on a motion to dismiss or a summary judgment motion and there are some difficult legal issues that you want to navigate through, we get called in to help the team triage those issues and figure out, okay, what's the best position that we can take here. For example, we have a class action that we were just retained for, where it's going to be, it's like a civil procedure smorgasbord where you're bringing a motion to dismiss at the same time as motion to compel arbitration, at the same time as possibly a motion to transfer. Like in weighing those issues, you're there as the appellate lawyer to say, okay, if this has to go up to the 4th Circuit or the 5th Circuit or the 9th Circuit or wherever, what's the best way to frame these issues? This morning, so that's sort of in the background of everything that I'm doing, and then you've got the day-to-day things that come up, right? So today, for example, I did a moot for a colleague who has a case before the 6th Circuit. It's an en banc case, so that means she has to argue before every single judge of the 6th Circuit, and so that's when you want to lay on the fire. So we have these sessions called moots, where we ask questions and we just go for an hour and a half, asking questions and trying to ask every question that we possibly can in the role of the judge to prepare the person arguing for the case. And we'll usually, for a case, an appeal, we'll do 2 or 3 of these. If you've got a Supreme Court case, you'll do 4 or 5, depending on the lawyer. And then earlier today, I was trying to negotiate a settlement with the other side in one of my cases. Yesterday I had a sweepstakes emergency come up, which I didn't know was a thing, but it was, we need to clear this contest and we need advice right away. So that the gaming part of my practice kicked in. So what I would say is, you've got the things like in the long term that you're working on in terms of your cases, and those are always running, and things will come up day to day in 1, 2, 3, 5, hopefully not 10 of those cases at once. And then things pop up throughout the course of the day that you're not really expecting. And a lot of the excitement is, the challenge of going from thing to thing and trying to, put out fires while also making meaningful progress on the cases that you're working on.
That's fantastic. Thank you, Andrew, for a lot of good insights there. So Victoria, on to you. What are the typical matters that you'd work on, and what is your day-to-day working on, I guess, international arbitration matters?
Well, you certainly can't be afraid to travel. At present, I'm in North Carolina. At present, I'm in North Carolina. I met with a witness to help write his statement in service of an international arbitration against a Chinese manufacturer. Tomorrow, I'm meeting with a client that is a international manufacturer of a worldwide denim brand and service of an arbitration against their Colombian licensee. And then later meeting with another client back in Charlotte, North Carolina. It's a real estate dispute, which usually don't go to international arbitration because usually your tenants are located in the country where you are. So you agree to like a US court. But in this case, the tenant is a UK-based clearing bank. So it's a fun intersection of some of the more domestic disputes I used to do and more of the international things that I do now. And my travel is also international. Next month, I'll be teaching a international arbitration course to associates in Amsterdam. And then I think I'm due back in London in May for a different arbitration sort of a meeting with the client. So it's all about some sort of dispute about a contract. Even when you have a national practice, often your clients are everywhere. So that takes you all across the country. With mine, it just sometimes takes me all across the world. And I often end up doing Zoom calls like this from a hotel room, not unlike this one.
All right, thank you, Victoria. And Jackie, on to you. So what are the typical matters you'd work on, and what does your day-to-day look like in IP litigation?
Yeah, so I just want to actually echo what Victoria said. And if I could offer one piece of advice to everyone when you become an attorney, is to pick an airline and to pick a hotel chain because you're going to be traveling all over the country. We also travel all over the world taking depositions, defending client depositions. As a second year associate, I got to travel to Norway, London, and Scotland to defend a deposition. So you're going to need to rack up those miles and save for a vacation. But as an associate at Fish, you get to pick what matters you want to be staffed on. We have kind of a free agency model. And so today, as a fifth year, I'm staffed on approximately 8 cases that range a wide variety of technology. One of my cases relates to car parts. It's a design patent case. We also have for some pharmaceuticals, we have oil and gas, and I'm also on a semiconductor case. And so depending on where the litigation is, basically dictates what I'm going to be doing that day. Litigation is predictably unpredictable. There are some mornings I wake up, I think it's going to be a quick, easy day, maybe a couple of meet and confers. Nope, it ended up being a 14-hour billable day. All these fires came up, all these emergency fire drills that needed to be addressed. But as an associate, I'm going to be on meet and confers. I'm going to be handling discovery, whether that's sending or responding to subpoenas, interrogatories, preparing witnesses for depositions. Also, one facet that's unique to patent litigation is that we heavily rely on damages experts as well as technical experts in the field of the patent. So we're working with experts to write their reports with them. We're preparing them for deposition, motion practice, that kind of thing.
Awesome. I'm actually going to ask a very, very quick follow-up question is how has the travel as a litigation attorney been impacted since COVID? I'm just very curious to hear that very briefly because I think that'd be helpful for students on the webinar.
I don't know about you all, but
go ahead, Victoria. Yeah.
Oh, sorry, Jackie. I was the advice to pick a hotel brand and stick with it is really good. I don't know about you, Jackie, but I'm back full force, maybe more than ever before pre-COVID.
I agree with that. One thing I will say is that I have noticed some judges are more amenable to telephonic hearings versus before they say, nope, you need to come to Chicago or Waco, Texas for that 1-hour meeting. Not so much anymore. And it's the same thing with depositions. We used to have to fly to Australia for a 2-hour deposition. Now we can do that remotely.
All right, so I'm sure this makes a big difference. Yeah, no, thanks for that. I'm sure that's. I've been curious about that. I'm sure it's helpful for a lot of members of the audience. All right, so
don't be an appellate lawyer if you want to travel. Our travel is not as glamorous as Jackie and Victoria's and Shauna's.
I will say that I'm traveling less, but I cannot think of a better piece of advice that anyone should take away from this than figure out your loyalty programs ASAP, because my husband and I paid for our honeymoon with points alone. It's a great thing.
if you're an entrepreneur meeting with law firms and going to conferences, it's also good to pick an airline. I can tell you that. So, all right. So so Andrew and Victoria, I'm curious to hear your thoughts. So for a student who's interested in litigation, but not sure really how to differentiate between them all, in your mind, what are the main differences between the different sub areas of litigation, and what are the differences between your area of litigation and other litigation practices? I guess Andrew, let's start with you.
So as I mentioned, one thing about appellate litigation is that we are, you know, subject matter generalists, but procedural specialists, meaning that we are, when people ask, we need to get emergency relief from the Court of Appeals because we just lost this injunction in the district court, like, people come to us to like figure that out. Or if you need emergency relief from the Supreme Court, the shadow docket looks very intimidating, and so we're here as guides to sort of work through the process with you, and we work with the Jackies and the Shaunas. I don't do a lot of arbitration related work, and usually that's a little more cut and dry, but to some extent the Victorias of the world, and we rely on them as the case experts. And our role is to say, okay, you've taken the case this far. If you need something from the Court of Appeals, either because you've lost a case in the trial court, if you won a case in the trial court, or you're trying to get emergency relief from the Court of Appeals, here's the best way to do it. So in that sense, I'm the worst person to ask this question, just because appellate lawyers kind of cheat because we don't have to specialize, but those of us who work in appellate litigation often do specialize. So I work a lot in the consumer finance space, and in the white collar, and and administrative law litigation. So if there's if you want to sue over what a federal agency has done, that actually comes to us, even though it's not strictly appellate. In terms of differentiate, like when you're starting out as a first year associate or as a summer associate at a law firm, like you're not really in a position to like pick a litigation practice and say, I want to do that. Like very rarely does the person have enough experience to say, like, if you did, life sciences work before, and you were, if you did pharmaceutical work before law school and you say, I want to do like pharmaceutical patent work coming in, like that's a little different. But most folks who are coming into litigation just from out of law school, or their second year summer associate, or their first year litigation associate, they're not going to necessarily know what they want to do in terms of litigation. So my advice usually is just to be a sponge, like to absorb as many experiences as you can and figure out like what gets you up in the morning, like what kind of work excites you, and like what do you enjoy working on, not just from a process perspective of like, I like motions to dismiss, or I like depositions, or I like trial work, and trial lawyers are all adrenaline junkies, but also the industries that you want to work with. Like I really like working with banks and like knowing how they run. Pharma companies really excite me because I like being on sort of working with cutting edge innovative products, and spend the first 2 or 3 years trying to figure that out for yourself, before you dive in. Now with like, and I'd be interested in Victoria's perspective on this, but like there are some niche areas where you need to dive in sooner rather than later. But my general advice for general litigation associates has been just like be a sponge, absorb as much as you can, and find what gets you up in the morning.
No, that's great advice. Thanks, Andrew. Yeah, Victoria, curious to hear your thoughts.
Yeah, I started out in general litigation and tried everything and found that the people I liked, and I think that's the most important part, the people you like, but the people I liked and the work I liked was in the international arbitration space. So I pursued them pretty relentlessly. I would write them articles and invite them to co-author with me. I would, politely but persistently offer to plan conferences or offer to come up with a different article. Write them a script for a podcast. And eventually I bothered them so persistently and so politely, they started staffing me on cases. And then I did a good job and they couldn't get rid of me. And that's part of how I made partner. So some of it is a choose your own adventure. But I think when you're first starting out, to Andrew's point, be a sponge. And I think in litigation, things generally fall into 2 buckets, the contract bucket or the tort bucket. And in the contract bucket, there's, purchase sale agreements, but there's also, a patent really at bottom is, I think, a contract, one that you register. Jackie can talk more about that. A security, it's something that you buy. It's an investment in a company. It's a contract. It's figuring out what kind of contract you like, what kind of industry you like, what team you like working with and pursuing it. And the tort bucket, that's a breach of a social contract. That's representing a company where somebody's accused them of hurting them. That's, well, I'll lump family law in there. I mean, that's a, breach of a social contract or a breaking up of a social contract. And then there's, premises liability. You're not keeping your house safe for your guests and you've breached a social contract. So maybe you like sort of the injury piece and working with medical experts of the tort bucket. So it's, I think, basically divided in those two broad areas, and then you narrow it down to see what it is you like. I think I overextended on a patent as a contract, so maybe Jackie can fix that for me.
Thanks for that, Victoria. So Jackie and Shauna, on to you guys. A different question. So both of your practices cover, I mean, both of your practices cover a wide variety of industries, legal issues, and clients. And it's definitely a theme that's running through the discussion tonight is how many different things you learn as a litigation attorney. What is the most challenging part of your practice? And which is the part that you enjoy the most? I guess, Shauna, I'll start with you.
I think I'm going to have the same answer as every other person here. The most challenging part of my practice is dealing with opposing counsel, judges, and clients. Without fail, every single time. Those are the three people that can make our lives truly hellish. But you sort of take that with the good, right? Like I really like I said, and I think many people have said here, working with the teams of people that I work with. They are wonderful. We do interesting things all the time. I get to mentor really great, talented young lawyers regularly. And I love watching them develop and seeing their skills just continue to evolve. And I saw somebody put in the chat a question about what young lawyers get to do. And the answer is that at our firm at Allen Matkins, if you are a good junior associate, you can take a witness in an arbitration, right? I actually had a first-year associate do that last year. She was the master of the case. She knew everything about it. And so she got to take a small witness at an arbitration. And that's what happens when you show the people you work with, like Victoria, that you are persistent and relentless and you will work your ass off. So that's the most exciting part of my job. And obviously the most challenging part is dealing with opposing counsel.
Unless it's any of the firms on this call, then of course
I've never been opposite any of these lovely people, and I think they would be a pleasure to be opposite.
Jackie, what are your thoughts?
Yeah, I mean, I definitely echo what all of the panelists have said so far. So from an associate perspective, I think the most challenging aspect of my day-to-day is preparing for trial. And we're talking about very complex technologies here, right? I mean, if you have an iPhone, at least 1,000 patents involved, pharmaceutical formulations, semiconductor devices. Our job as complex patent litigation trial attorneys is to convince a jury that has the educational level of a high schooler why they should award our client $500 million. And so going through the whole litigation, all the different milestones, how can we build that case? How can we build that story? And not only build a story, but say it in a compelling, persuasive, non-condescending way. This is complex stuff, complex legal issues, but we don't want to turn the jury off to us by the way we come off. Double-edged sword though, right? What makes the job so challenging is what makes it very rewarding. And every single day there's different issues. No two cases are alike, even if the technology is similar. So there's always something for me to learn. As an associate, you do want to just sponge up all of the information you can glean. You want to raise your hand for those opportunities. And that's where you do find yourself being able to take depositions or have a speaking role at trial.
That's a great answer. Thanks so much, Jackie. I'm actually going to stick with you for one bonus question.
Sure.
So I know you have an advanced degree. You mentioned that earlier, and I know a lot of IP attorneys do have advanced master's degrees or PhDs. So this is a common question that comes up from law students. I want to make sure we cover this. Is it required for an intellectual property litigation attorney to have a hard science background or an advanced degree?
No. I'm going to say no, but okay. I'm not going to say the classical it depends answer, because for litigation, the true answer is no. We have several incredible attorneys, several partners at our firm who have political science undergraduate degrees. They don't have any special STEM background. I will say this though, having an advanced degree can help you in certain situations where the client is looking for others with advanced degrees, right? It's complex technology. But on the same hand, it can be a token, or excuse me, it can be a handicap if you don't have an advanced degree, right? But in those instances, you might be staffed on a case where you can help out with discovery matters instead of technical matters. For example, I have a neuroscience background. I'm currently on a semiconductor case. I don't know anything about semiconductors. I'm going to learn throughout the course of this litigation, but I can still be an asset and contribute to the team by handling other matters, by handling the meet and confers, by handling discovery. So you do not need a technical degree. It certainly helps in some situations, but I would not let that dissuade you from pursuing a career in IP litigation.
No, thanks so much for that, Jackie. And it's also a great point. Something to keep in mind is even if you have an advanced degree, not every case you're on is going to be exactly in the specialty that your degree is in. So that's a great perspective. Thanks so much. Yeah. So before we move on to the next question, just a reminder: if you have any questions, pop them in the Q&A. Hopefully, we'll have time for one or two. And just a reminder: check the chat. We have all different links where you can sign up with the different firms, and we have the link to sign up for our flag raffle. Last chance to do that in a couple of minutes. So make sure you jump on that. All right. So we're going to move on to my personal favorite question. Which is, what is the most interesting or coolest case or legal matter that you've worked on? So Victoria, I'm going to start with you. What is the most interesting or coolest thing you've worked on?
Oh gosh. Last year I did a 6-week trial, a final arbitration hearing in Hong Kong. We represented a startup company that was making a satellite to shoot over sub-Saharan Africa to bring cell phone service to people there, because most people in Africa access the internet via cell phone. And at its core, it's a just massive shareholders dispute, but the company was valuated at like $4 billion. So two of the shareholders thought, well, if I'm just bad enough and noisy enough, the Chinese lenders will buy my shares from me. But that didn't happen. They were very invested in the company. And eventually these bad actor shareholders started raising so many red flags about, undue Chinese influence on a US tech company that they gave this interview to a national publication. Take the company. There's implications on a aerospace company that you would know about, a company that also launches satellites into orbit that you might know about. And we brought suit as a plaintiff, as a claimant, for the destruction of that company in Hong Kong. And there was US law and the law of England and Wales, because the Articles of Incorporation invoke those laws. Cayman Island law, because that's where the shareholders agreement invoked their law. We had legal experts from Hong Kong, and it was so cool to be instructed by a Hong Kong solicitor, to be across the aisle from a British Silk who's being instructed by Australian heritage solicitors, and to be in front of a tribunal that was comprised of former Hong Kong High Court judges and practitioners. It was the most international room I've ever been in, the most I've ever worked in my life, and the coolest experience, both personally and professionally.
That's great. Thanks so much, Victoria. Shauna, curious to hear from you.
That's hard to follow, but I will do my best. A few years ago, I represented Creative Artists Agency. It's a talent agency here in LA, in a dispute with the Writers Guild. So the Writers Guild filed a lawsuit, actually filed 4 lawsuits, but who's counting, against the various talent agencies in LA, alleging antitrust violations, as well as violations of the Racketeering, Influencing, and Corruption Act. I think I got that. Andrew probably can correct me if I didn't. But and so it was very interesting. It was also very divisive, because I do live in Los Angeles. And so a lot of my friends are members of the Writers Guild. And so we had a lot of interesting conversations. And it was one of the very few times, I think, so many of my friends were deeply invested in something that I was doing, and having, on the spot arguments about it. Ultimately, there was a settlement reached, but after a large portions of our motion to dismiss were granted. And so the writers live to write another day.
Right. And for those 1Ls who are taking criminal law this year, it's a good example of RICO in real life. So thank you, Shauna. Andrew, on to you. What is the coolest case you've worked on?
I have many choices, but I'm going to go with the one I find personally amusing, which is we were in the Court of International Trade, which is a court. And speaking of criminal law implications, we represented a client who wanted to import cannabis vaporizers into the country, and the vaporizers could be used only for cannabis and nothing else. And the importation of drug paraphernalia is illegal under federal law. However, the statute for drug paraphernalia has an exception for drug paraphernalia that is authorized under federal, state, or local law. And so we were like, look, these vaporizers are legal under Colorado law. Like, Colorado allows for recreational use of the cannabis, and like, this should be a plain application. The Court of International Trade went out of its way to be like, nope, I am not touching this with a 10-foot pole. I am not going to be the judge that lets cannabis vaporizers be brought into this country. No jurisdiction. You haven't shown irreparable harm, even though the declarations were like, our company will go like out of business if we can't import these vaporizers. They're like, I don't see irreparable harm here. Go away. And then 2 weeks later, I was at an event unrelated to what I do, and I happened to run into someone whose uncle was the judge who ruled against us, and she got a kick out of that story and said she was going to give him grief for it at Thanksgiving. And you get a lot of amusing moments. The other one I'll quickly plug is that we have a FOIA lawsuit against the National Archives right now, seeking the records of George W. Bush's meetings with Vladimir Putin. And it was a really fun complaint to write. Who says you can't do creative writing in law? Because among other things, we snuck in the George W. Bush quote about looking into his eyes and seeing into his soul. And I was just like, this is just, as a former foreign policy nerd, I just found that incredibly amusing. So yeah, you get to work on a lot of it. There are truly too many to pick from. But I find the cannabis story just really fun, just because it almost seemed meme worthy in a sense. So.
And FOIA, of course, referring to the Freedom of Information Act, where citizens can request records. Very, very fascinating. Thank you, Andrew. And then Jackie, on to you.
So one of my favorite cases so far has been where we represented a sole inventor who created a safety device for motor racing vehicles. And we ended up suing some really big names in the racing world. And I was an A2 at the time, the only associate on the case, and I was given opportunities that would more usually be reserved for more senior associates. So I got to take depositions of foreign deponents. I got to travel across the world to take these depositions. I got to engage in settlement discussions. Like, I was able to plug into all stages of that litigation, and it's really been a great foundation for me going forward, because I do have that, I guess, awareness of how something early on in litigation, how that can affect the end result. And we had a great result for our client, so it was just a good overall feeling.
Fantastic. Thank you, Jackie. All right, so we're going to move on to our last question. I want to make sure we stay on time. In 30 seconds, we're going to give out some prizes while we do this. So we're going to go take turns in 30 seconds or less, and we're going to be strict about the time. In 30 seconds or less, why should a law student choose your firm? So Victoria, I'm going to start with you. 30 seconds. Why should a law student choose Troutman?
We are a big law firm with an entrepreneurial mindset. Since I joined Troutman, we've gone from an AM100 to an AM50. Now we're in the AM30. And because of that, we're scrappy. We're supportive of whatever your endeavor might want to be. I am teaching in Amsterdam. I pitched a large pharmaceutical company to do their plaintiff's work. It's just openness and freedom that sometimes doesn't exist in the AM30s. And that's what I love the most about this firm.
Love it. All right, thank you so much. So, and right on time. All right, so we're actually gonna raffle off we have a Troutman swag package, and the winner is Sarah Khalife. If you're with us, please let us know in the Q&A if you're with us, Sarah. All right, Jackie, 30 seconds less. Why should a law student choose Fish?
So Fish is a premier patent litigation firm. We also handle trademark, copyright, trade secret disputes. If you are an associate, especially a young associate looking for experience, Fish gives you that hand-on experience. Like, Fish invests in you. They're very intentional as to their hiring. They want you to rise up through the ranks. They want you to be a principal. And I think the general work environment too is very cohesive to that, in the sense that I look at my fellow associates not as competition, but as my colleagues. Fish has 400 attorneys, and no one is out of reach. everyone is very helpful. They want to see succeed. They want to give you those opportunities to help you grow as a lawyer.
Great, thank you so much. And the winner of the fish swag package is Camilla Collante. If you're with us, please let us know in the Q&A. All right, Andrew, on to you. 30 seconds or less. Why should a law student choose Goodwin?
Honestly, if you're the type of person who takes their work seriously, but you don't take yourself seriously, we're the place for you. We work with a lot of interesting clients, and but quite frankly, all our firms have interesting clients, and like it's hard to differentiate, and like you got to find your people. But for us, like, I think the fact that you get to work on interesting matters. We represented Moderna during the pandemic, and a lot of different tech companies now doing exciting things. Come join us for that, and come join us just so you can be yourself.
Love it. Thanks, Andrew. And the winner of the Goodwin sponsored JBL headphones is Ricardo Martinez. If you're with us, let us know in the Q&A. All right, last but not least, in 30 seconds or less, Shauna, why should a law student choose Allen Matkins?
Allen Matkins is a firm you can go to and get experience. You will not be sitting in your office reviewing documents for tens of hours a day for 2,200 hours a year. You will be here and you will be drafting. You will be actually getting experience. You will be standing up in court, and you will be getting dedicated mentorship for everything, every step of the way. And that is something we are deeply committed to, and that's a deep part of our culture here.
Fantastic. And the winner of the Allen Matkins swag, it is a bunch of different things, from really cool stuff, including a gym bag and a towel, is Josette Peacock. So let us know if you're here, Josette. Let us know if you're here in the Q&A. Well, this is a really wonderful panel. One of the most common questions from associates is, what do you actually do as an associate in litigation? So I think Shauna just alluded to that, and that was also something commonly talked about tonight. So great topic for the breakout rooms. That's a good segue. Stick around to join the breakout rooms. That's a great question to ask. Just what is a day-to-day like, and what type of experience you can get as an associate. Super quick, again, if you haven't already signed up for the rest of our virtual series, the link is in the chat. We also have links in the chat for all the different firms if you would like to sign up with their one-on mailing list or engage with the firms otherwise. I'm going to open the breakout rooms in just a second. Pretty intuitive. You can just choose the room you want to go to and pop right in and ask questions. One thing I always like to mention is don't squat. Spend some time in all the different rooms. Take advantage of the different perspectives that we have in this group and all the time that everyone's taking out of their schedules to join us. Just wanted to say thank you to this wonderful panel for joining us tonight. This is really, really insightful. Really excited to have this group together, and hope everybody can stick around to join the breakout rooms. Thank you so much.